Hi everyone, good evening and welcome to Thorough Newspaper Analysis. Now this is the video for 25th of June 2024. Now let's proceed and have a look at the pointers of discussion for the day. So first of all, in the editorial segment for today's discussion, we have an Indian Express article. Now this article is yet another article in the series of articles that we've done on the entire matter of the alleged liquor scam case that happened in Delhi. So now recently something has happened and as a result, again, the debate over twin test, which is to be followed while granting or disallowing bail applications under the PMLA. So we'll understand what has happened recently, whether bail has been granted, whether it has been stayed to the Chief Minister of Delhi, and what is this twin test. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start and let's first have a look at the title of this article. Bail in money laundering cases and the twin test under PMLA. Now let me give you a context to the recent development. So please understand, recently a trial judge granted bail to the Chief Minister of Delhi, Mr. Arvind Kejriwal. Now as and when this happened, the Enforcement Directorate, which is the agency concerned, which is handling this entire matter, so it sprang into action and it approached the Delhi High Court. Now, what was the contention before the Delhi High Court, which was advanced by the counsel representing the ED? So the counsel was essentially saying that the trial judge did not rightly peruse the material that the Enforcement Directorate submitted before it. So there was no application of mind by the trial judge while granting bail. And as a result, this bail order, it should be stayed. The Delhi High Court agreed with the Enforcement Directorate's plea, and the Delhi High Court, as a result, stayed this order. So I'd like to quote one para from the order of the Delhi High Court, and I would like to read it out. So the High Court said that the vacation judge, while passing this impugned order, by impugned order, we mean the order which is under challenge. So the Delhi High Court said that the vacation judge, while passing the impugned order, did not appropriately appreciate the material or the documents which were submitted on record, and also did not appreciate and consider the pleas taken by the ED and the averments or the grounds as raised in the petition filed under section 439 clause 2 of the CRPC, which requires serious consideration while dealing with the said petition. Accordingly, this present application, it is allowed, and the operation of the impugned order, it is stayed. So this was the order of the Delhi High Court. Now, in light of this context that I just gave you, let's read it out. So a day after a trial judge granted bail to the Chief Minister of Delhi, Mr. Arvind Kejriwal, who is in jail on charges under the Prevention of Money Laundering Act, the Delhi High Court, it has stayed this order. A bench which was headed by Justice Sudhir Kumar Jain, it heard an urgent request which was filed and put forth by the Enforcement Directorate to halt this bail decision, or to say to stay the bail decision. The ED essentially argued that the trial court did not follow the required rules, also known as the twin test, for granting bail under the PMLA. The court reserved its judgment, a decision, until next week. So in light of this, let's understand what is this twin condition, this twin test which is to be followed, and why is bail under PMLA so contentious. Please understand there is a section called section 54 under the PMLA. This section essentially deals with bail. It broadly, reflects upon or provides for two things. Firstly, that no court can grant bail for offences under this law. This law means the PMLA. So no court can grant bail for offences under the PMLA. And then this section proceeds to mention a few exceptions wherein bail can be granted. So the negative language that, no court can grant bail, this negative language in the provision, it itself shows that bail is not the rule, but it is an exception in the PMLA. On the other hand, we know how there have been celebrated judgments by, judges like Justice Krishnan Iyer, who have said categorically that bail is the rule and jail is the exception. But on the contrary, here what we see is that there is a negative language which is used, and it shows that bail is not the rule, rather it is the exception. The law makes it mandatory that in all bail applications, the court must hear the public prosecutor. So the first and foremost requirement is whenever a bail application is moved by an accused, then firstly, the public prosecutor has to be heard. And when the public prosecutor opposes the bail application, which is, a likelihood in almost each and every case. So whenever the public prosecutor opposes the bail, then the court applies a twin test. By virtue of this test, two conditions are to be satisfied. Firstly, it has to be established that and that there is reasonable ground to believe that the accused is not guilty of the offense. So it is on the accused that he proves that he is not guilty of the offense. And secondly, that the accused is unlikely to commit any further offense while he is enlarged or released on bail. So these are the twin conditions. Also, please understand there are several, special legislations or statutes or laws which deal with very serious offenses, such as the Drugs and Cosmetics Act. Then we have the NDPS Act, the UAPA, which is the Unlawful Activities Prevention Act. All of these acts, they require that the public prosecutor be heard in bail applications. Now, these laws, they also often require the court to assess if there are reasonable grounds to believe the accusation is not prima facie true before the bail is granted. Now let's understand whether there has been a challenge to this twin condition law in the past, as in whether the constitutionality of section 54 of the PMLA, it was ever challenged. So the answer here is yes. The first blow to the constitutional validity to this twin test, it came about in the year 2017 in the case of Nikesh Tarachand Shah versus Union of India. So please understand, in 2017, Justices Rohington Nariman and Sanjay Kishan Kaul of the Honorable Supreme Court held that bail conditions under the PMLA, and it is unconstitutional due to unreasonable criteria. Now, despite this, the Parliament reintroduced these provisions a year later through the Finance Act. So challenges as a result ensued, leading to a 2022 Supreme Court case, which is titled as Vijay Madanlal Chaudhary versus Union of India, which address the reinstated provisions validity. In the case challenging the reinstated bail provisions, petitioners upheld the reasoning of Nikesh Tarachand Shah, which was this 2017 judgment here. And while doing so, so this was the petitioner's side that it reinstated the reasoning which was delivered in the 2017 verdict. But Justice A.M. Khanvilkar's three-judge bench, it rejected this move. The court emphasized Parliament's authority and dismissed doubts raised about the seriousness of money laundering under PMLA. Legal experts, however, they question equating money laundering laws with stricter anti-terror and narcotic laws due to the lesser maximum sentence, which is up to 7 years, except when narcotics are involved, extending up to 10 years. Now, the government's argument in court is that individuals who are engaged in money laundering cases, they're influential, they're intelligent and resourceful, often planning the crime very meticulously to evade detection. They assert that these crimes, they involve advanced technology to conceal transactions, thereby making it very difficult for the investigative agencies to uncover the evidence. As a result, they justify stringent bail conditions to prevent those accused from obstructing justice or fleeing prosecution. So this was the stance of the government, that because the nature of PMLA offenses is such and such that, highly skilled people with very meticulous plans, use of advanced technology are committing these offenses. And as a result, the prosecuting agencies, they're left with very little tools at their disposal to uncover the offenses. So as a result, bail conditions should be harsher. The granting of bail, the test or criteria for that, it should be harsher. Now let's understand the current position in law. So one key aspect of the challenge to the amendment on bail conditions, it still remains open even after the judgment of in 2022 case of Vijay Madanlal, and that is the passing of these amendments through the money bill route. Now we know that there are certain laws or certain acts which are called money bills, and there are certain special provisions with respect to money bill. The power of Rajya Sabha is reduced significantly, so therefore oftentimes the government takes the route of money bill so that the process of passing this particular bill, it is easier. A pending challenge before the Supreme Court questions the classification of laws like the Aadhaar Act and the tribunal members' service conditions as money bills, awaiting a bench to be formed for consideration. So a very huge controversy arose while Aadhaar Act, it was presented as a money bill. So the matter is still pending for consideration before the Supreme Court. Meanwhile, Supreme Court's ruling in the case of Vijay Madanlal Chaudhary, it remains valid as no stay has been issued on the judgment despite the ongoing review proceedings. So the current law is as was given and laid down by the 2022 ruling. According to the ruling, the twin test, it must be strictly applied in all courts which are handling money laundering cases, including the special and the constitutional courts for both regular and anticipatory bail. Despite this, Section 436A of the CRPC, under this particular section, an accused can seek bail after serving half of the maximum sentence as an under trial. We did a TNA article a couple of days back on this particular section itself. This means that in most money laundering cases, if the Enforcement Directorate is not able to finish the trial within 3.5 years, then the accused is entitled to bail irrespective of the twin condition. I would like to brief you about this section. So see, essentially, it says that if an under trial has already spent half of the sentence which is prescribed for the offense for which he's being tried, so then he has a right of being released on bail. So mostly it is seen that the offenses under the PMLA, they are punishable with a term of 7 years, mostly, not all, but mostly. So therefore, if let's say an accused has already served while being under trial a sentence of 3.5 years, then he is entitled to bail irrespective of whether this twin test it is followed, it is complied with or not. Now this has brought us to the national news for the day. So now let's start with the national news, and this is the first update. Amit Shah launches special program to fast-track immigration services. Amit Shah, he's recently launched a special program, and this is done for the purpose of facilitating an easy access and fast-track procedure for immigration purposes. So under this particular program, immigration process of pre-verified Indian nationals and also for OCI card holders, it will be fast-tracked. OCI stands for the Overseas Citizens of India. Next up is an update from Telangana. Telangana State Cabinet approves proposal to waive crop loans for each farmer in the state by August 15th. The State Cabinet for the state of Telangana, it has approved waiving up to 2 lakh rupees of crop loans for, and this is done per farmer by 15th of August, thereby fulfilling a promise that was made in last year's assembly election. The Chief Minister for the state, he announced that crop loans which were taken by the farmers between the duration or the period of 12th of December 2018 to 9th of December 2023, it will be eligible for a waiver. World's first Asian king vulture conservation and breeding center, it has come up in UP. So the UP government, it is to establish world's first Asian king vulture conservation and breeding center. And this is the venue for that is Maharajganj. This is very important, students. Please make a note of it. So the facility, it aims to improve the population of the species. And please understand, this particular species, it has been listed as a critically endangered species in the International Union for Conservation of Nature's Red List. And this has been going on since the year 2007. So there is a very imminent, urgent need of, reinforcing conservation efforts. This is the world's first center for breeding and conservation of Asian king vulture, also called the red-headed vulture. This is very, very important update. Next up is an update from Andhra Pradesh. Ayyanna Patrudu, he is unanimously elected as the Speaker of the AP Legislative Assembly. Ayyanna Patrudu has been elected as the Speaker of the Andhra Pradesh Legislative Assembly unopposed, or to say unanimously. Madhya Pradesh government approves the establishment of one Prime Minister College of Excellence in all districts of the state. So under the National Education Policy of 2020, the Madhya Pradesh government, it has now approved the establishment of one Prime Minister College of Excellence in all the districts of the state. The Chief Minister, Dr. Mohan Yadav, he announced plans to introduce a drone facility during meeting on the Higher Education Department's activity. Apart from this, educational gardens, which are called the Vidya Vans, they will be established in all government, non-government and aided colleges in Madhya Pradesh. And this is to promote environmental protection awareness among students. Now, this is also a very important update. Rear Admiral Nelson D'Souza, he takes over as the Commandant, Military Institute of Technology, Pune. Rear Admiral Nelson D'Souza, he is taken over as the Commandant of the Military Institute of Technology, Pune, from Air Vice Marshal Vivek Gloria. BJP's JP Nadda, he is the leader of House in Rajya Sabha. The Bharatiya Janata Party National President and the Union Health Minister JP Nadda, he was named as the leader of the House in Rajya Sabha, replacing Piyush Goyal. The BJP has been allocated the Ministry of Health and Family Welfare in the new NDA government. Additionally, 11 members from the upper house, they are part of the Union Council of Ministers. Now, this is an important update. So with this, now we tackle the segment of important days. And the important day concerned for today is International Olympic Day. Olympic Day, it is observed annually on 23rd of June. This is very, very important. Please make a note of it. And given the fact that, this year we are going to observe the Olympic season. So Olympic Day, it is observed annually on 23rd of June, starting from the year 1948. And this is to honor the rebirth of the Olympic Games in Paris on 23rd of June back in 1894. It also marks the official formation of the International Olympic Committee on that historic day. So as far as the theme for this year's celebration is concerned, it is Let's Move and Celebrate. It is aimed to inspire people world across or worldwide to engage in daily physical activities. Now we talk about the international news for the day, and the first update is from Malawi. Malawi, please understand, it's a country in East Africa. So Michael Usi is sworn in as Malawi's vice president, and he was a comedian now turned politician. Michael Usi, he has been sworn in as Malawi's vice president, and this has happened due to the death of former vice president Solos Chilima in a plane crash. He has been nominated based on his substantial knowledge and charm to address the country's challenges and advance development projects. India and Qatar discuss sale of Mirage 2000 fighters to the Indian Air Force. India and Qatar held key discussions in New Delhi on the proposal to buy 12 second-hand Qatari Mirage 2000 fighter jets for the Indian Air Force. Qatar has offered rupees 5,000 crore for 12 aircraft, but India is looking for a more reasonable price. Please understand, in 2021, the Indian Air Force signed a rupees 300 crore deal with a French company to purchase phased out Mirage 2000 aircraft for spare parts. So if the Qatar deal proceeds, then the Indian Air Force's Mirage aircraft fleet will increase to a total number of 60. Sino-French satellite launched into orbit. The first astronomy satellite developed by China and France, the most powerful for studying farthest explosion of stars, it was launched into orbit. The satellite studying gamma ray, it was launched from China's Xizang Satellite Launch Center, and this is in Xizang province. The Space Variable Objects monitors launch. According to Chinese National Space Administration, it will contribute to astronomical discoveries. So for our purpose, what we need to understand is the countries collaborating, the launch, what is it called, and what is its purpose. Russia approves draft logistics agreement with India. So, a significant step towards strengthening military cooperation, the Russian government has approved a draft logistics agreement with the Indian government. This agreement will simplify military to military exchanges from exercises, training, port calls, humanitarian assistance, and disaster relief efforts. This agreement, it will last for a total of 5 years, and such agreements, they are important for expanding India's strategic reach and operational readiness, thereby allowing a longer and more complex military deployment. Now, this is also a very, very important update. Spanish Grand Prix, Max Verstappen, he finishes top of the podium. So Max Verstappen, he has won the Spanish Grand Prix, marking his 7th victory out of the 10 races that have taken place during the season of 2024 to 2025. This is a very significant update. So out of the 10 races that have taken place during the season of 2024-2025, he has secured the podium rank of first in 7 of those races. So following his victory, he has reached 219 points in the Drivers' Championship, thereby establishing a considerable lead over Lando Norris, who is currently holding 150 points in the second position. Now with this, we come to the legal news update segment, and the first update is from the Honorable High Court of Delhi. So the Delhi High Court bench of Acting Chief Minister Manmohan and Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora, it has held that a party which did not participate in a tender process, it lacks the standing to challenge the tender's award. The bench held that such a party has no right to voice grievances regarding the tender. The High Court ruled with respect to this particular case that since the petitioner here did not actively participate in the tender process, so therefore, it lacked the standing to challenge the tender awards despite issuing a commitment letter. Thus, the court held that non-participants, they cannot claim rights or challenge the tender's outcome. The name of this particular case is Micheal Fibcom Limited versus the Indian Oil Corporation Limited and others. Now, next up is an update from the Honorable Supreme Court. So here, this is with respect to the Negotiable Instrument Act. So here, the Supreme Court has observed that transfer of a case for the offense of dishonor of check under Section 138 of the NI Act, it cannot be sought at the instance of the accused. The name of this particular case is Kasturi Pandian versus the RBL Bank Limited, Kasturi Pandian. So now this has brought us to an end of our TNA. Thank you so much for watching. Have a wonderful day ahead.